Supreme Court of India Mukhtar Zaidi vs. State of Uttar Pradesh and another decided on April 18, 2024 SEC Online SC 553 Facts of the case. FIR was investigated and after investigation the police report under section 173(2) CrPC was submitted according to which the investigating officer found that no evidence could be collected which could substantiate the allegations made in the FIR. The informant filed a protest petition along with affidavits to show that the investigation carried out by the investigating officer was not a fair investigation. The CJM, by order dated March 8, 2021 rejected the police report under section 173(2) CrPC and further proceeded to take cognizance for offences under sections 147, 342, 323, 307, 506 of the IPC and under section 190(1)(b) of the CrPC and also directed that the matter would continue as a state case. Accordingly, it summoned the accused. Petition of the appellant under section 482 CrPC was dismissed by the court. Findings of the court. This court on the point as to how the magistrate would proceed under section 190 CrPC. Once the investigating officer had submitted a closure report under section 173(2) CrPC, in the case of Vishnu Kumar Tiwari vs. State of Uttar Pradesh, through Secretary Home, Civil Secretariat, Lucknow, 2019, 8 SCC 27 laid down the legal position relying upon previous judgments of this court. In the said case the facts were quite similar to that of the present case where affidavits were filed along with the protest petition. The net result is that the magistrate in the present case ought to have treated the protest petition as a complaint and proceeded according to Chapter 15 of the CrPC. It is also reflected that the magistrate also had the liberty to reject the protest petition along with all other material which may have been filed in support of the same. In that event the complainant would be at liberty to file a fresh complaint. The right of the complainant to file a petition under section 200 CrPC is not taken away even if the magistrate concerned does not direct that such a protest petition be treated as a complaint in the present case, as the magistrate had already recorded his satisfaction that it was a case worth taking cognizance and fit for summoning the accused. We are of the view that the magistrate ought to have followed the provisions and the procedure prescribed under Chapter 15 of the CrPC. Accordingly, we allow this appeal, set aside the impugned orders passed by the High Court as also the CJM Aligarh. However, we leave it open for the magistrate to treat the protest petition as a complaint and proceed in accordance to law as laid down under Chapter 15 of the CrPC. We make it clear that we have not made any comments on the merits of the matter and any observations made would not influence the CJM in taking an appropriate decision as required above.